Rules on Civil Procedure, Rule 19, Intervention, Section 1. Who may intervene? A person who has a legal interest in the matter in litigation or in the success of either of the parties or an interest against both, or is so situated as to be adversely affected by a distribution or other disposition of property in the custody of the court or of an officer thereof may, with leave of court, be allowed to intervene in the action. The court shall consider whether or not the intervention will unduly delay or prejudice the adjudication of the rights of the original parties, and whether or not the intervener's right may be fully protected in a separate proceeding. Section 2. Time to intervene. The motion to intervene may be filed at any time before rendition of the judgment by the trial court. A copy of the pleading in intervention shall be attached to the motion and serve on the original parties. Section 3. Pleadings in intervention. The intervener shall file a complaint in intervention if he or she asserts a claim against either or all of the original parties, or an answer in intervention if he or she unites with the defending party in resisting a claim against the latter. Section 4. Answer to complaint in intervention. The answer to the complaint in intervention shall be filed within 15 calendar days from notice of the order admitting the same, unless a different period is fixed by the court. Rule 20. Calendar of cases. Section 1. The clerk Calendar of cases. The clerk of court, under the direct supervision of the judge, shall keep a calendar of cases for pre-trial. For trial, those whose trials were adjourned or postponed, and those with motions to set for hearing. Preference shall be given to habeas corpus cases, election cases, special civil actions, and those so required by law. Section 2. Assignment of cases. The assignment of cases to the different branches of a court shall done exclusively by raffle. The assignment shall be done in open session of which adequate notice shall be given so as to afford interested parties the opportunity to be present. Rule 21. Subpoena. Section 1. Subpoena and subpoena desus tecum. Subpoena is a process directed to a person requiring him or her to attend and to testify at the hearing or the trial of an action, or at any investigation conducted by competent authority, or for the taking of his or her deposition. If it may also require him or her to bring him with him or her any books, documents, or other things under his or her control, in which case it is called a subpoena desus tecum. Section 2. By whom issued? The subpoena may be issued by the court before the court before whom the witness is required to attend. B. The court of the place where the deposition is to be taken. C. The officer or body authorized by law to do so in connection with investigations conducted by said officer or body. Or D. Any justice of the Supreme Court or the Court of Appeals in any case or investigation pending within the Philippines. When application for subpoena to a prisoner is made, the judge or officer shall examine and study carefully such application to determine whether the same is made for a valid purpose. No prisoner sentenced to death, reclusion perpetua, or life imprisonment, and who is confined in any penal institution, shall be brought outside the said penal institution for appearance or attention or attendance in any court unless authorized by the Supreme Court. Section 3. Form and contents. A subpoena shall state the name of the court and the title of the action or investigation. Shall be directed to the person whose attendance is required, and in the case of subpoena de tecum, it shall also contain a reasonable description of the books, documents, or things demanded, which must appear to the court prima facie relevant. Section 4. Quashing a subpoena. The court may quash a subpoena de tecum upon motion promptly made and in any event or at before the time specified therein if it's unreasonable and oppressive, or the relevancy of the books, documents, or things does not appear, or if the person in whose behalf the subpoena is issued fails to advance the reasonable cause of the production thereof. The court may quash a subpoena ad testificandum on the ground that the witness is not bound thereby. In either case, the subpoena may be quashed on the ground that the witness fees and kilometrage allowed by these rules were not tendered when the subpoena was served. Section 5. Subpoena for depositions. Proof of service of a notice to take a deposition, as provided in Section 15 and 25 of Rule 23, shall constitute sufficient authorization for the issuance of subpoena for the persons named in said notice by the clerk of court of the place in which the deposition is to be taken. The clerk shall not, however, issue a subpoena de tecum to any such person without an order of the court. Section 6. Service. Service of a subpoena shall be made in the same manner as personal or substituted service of summons. The original shall be exhibited and a copy thereof delivered to the person on whom it is served. The service must be made so as to allow the witness a reasonable time for preparation and travel to the place of attendance. Cost for court attendance and the production of documents and other materials subject of the subpoena shall be tendered or charged accordingly. Section 7. Personal appearance in court. A person present in court before a judicial officer may be required to testify he or she were in attendance upon a subpoena issued by the court or officer. Section 8. Compelling attendance. In case of failure of a witness to attend, the court or judge issuing the subpoena, upon proof of the service thereof and of the failure of the witness, may issue a warrant to the sheriff of the province or his or her deputy to arrest the witness and bring him or her before the court or officer where his or her attendance is required. The cause of the such warrant and seizure of such witness shall be paid by the witness if the court issuing it shall determine that his or her failure to answer the subpoena was willful and without just cause. Section 9. Contempt. Failure by any person without adequate cause to obey a subpoena served upon him or her shall be deemed a contempt of the court from which the subpoena is issued. If the subpoena was not issued by a court, the disobedience thereto shall be punished in accordance with the applicable law or rule. Section 10. Exemptions. The provisions of Sections 8 and 9 of this rule shall not apply to a witness who resides more than 100 kilometers from his or her residence to the place where he or she is to testify by the ordinary course of travel or to a detention prisoner if no permission of the court in which his or her case is pending was obtained. Rule 22. Computation of time. Section 1. How to compute time. In computing In computing any period of time prescribed or allowed by these rules, or by order of the court, or any applicable statute, the day of the act or event from which the designated period of time begins to run is to be excluded, and the date of performance included. If the last day of the period of thus computed falls on Saturday, a Sunday, or a legal holiday in the place where the court sits, the time shall not run until the next working day. Section 2. Effect of interruption. Should an act be done which effectively interrupts the running of the period, the allowable period after such interruption shall start to run on the day after notice of the cessation of the cause thereof. The day of the act that caused the interruption shall be excluded in the computation of the period.